Summarizing is a basic mediator tool that is helpful in all mediations, not just in ones when self-represented litigants are participants. It is particularly important in mediations involving self-represented litigants because it can empower them by doing the following: stating the self-represented litigant's concerns more clearly than the self-represented litigant can do for themselves, making the mediation more comprehensible for the self-represented litigants and other participants, and slowing down the process to allow self-represented litigants more time to process the information and its implications. Here's an example of a mediator using a summary to restate the concerns of a self-represented litigant.
I've been a tenant at an apartment complex for about 2 years now, where Carla Robertson has been my landlord. And I'm here today because I'm really confused. I've received 2 3-day notices, and one of them, I believe, was to pay or quit, and another was to perform or quit, something like that. I think I remember. And I feel really confused because I've never been, bad at paying rent. She gets the rent every month. I always pay. There's not a problem there. I may be a little late sometimes, and I understand, but I do give her a call. I always let her know when this is going to happen or when this is the case for me. Mm-hmm. She's always really understanding. Mm-hmm. She's never had any comments about my 2 dogs, Frankie and Jessie, whom I've had since they were puppies, and we all moved in together. I consider them my children, mm-hmm. really. I live alone, and so they're my companions, and they really are my children. Mm-hmm. And she didn't have a problem with this. And now, 2 years later, all of a sudden, I received these notices, and all I can think of is the last time I spoke with her, I asked her to make some repairs mm-hmm. in the apartment. For example, my sink is broken. It only has cold water, so that can be pretty chilly in the winter. Mm-hmm. Also, my bathroom has mold. There's flies and bugs coming from under the tub. And that's really disturbing to me because mm-hmm. I do pay a fair amount of rent each month, and I shouldn't have to deal with these issues. Also, my oven is broken. The seal doesn't work, so I can't use it. Mm-hmm. So really I have the stovetop and the microwave, and that's also bothersome to me.
Mm-hmm. So just so that I make sure I've heard you correctly so far, and I'll invite you to add anything that you may have not added yet or wanted to clarify after I let you know what I've heard so far. You've been at this property for about 2 years or so, and Carla's been the landlord this whole time. Is that correct?
Yes.
From what you've said, you've had a good working relationship with Carla so far in terms of being able to pay rent. You get the rent in every month, even though it might be a little late. You mentioned that Carla's been very understanding of your situation. But you've also worked with her to let her know in advance when that's going to be the situation of getting rent in late.
Right.
You also mentioned that there are 2 dogs that live with you, Frankie and Jessie, whom you love and call your children. And you brought them in when you also moved in, and they were puppies at the time, and Carla hadn't mentioned any concerns or issues with them prior to fairly recently. Is that correct?
Right, exactly.
You mentioned...
The video that you just saw, Pauline gave a basic summary that we use in mediation. It was basic but important. Self-represented litigants need to feel heard. What we know from the research on procedural process is that parties, especially self-represented parties, have a strong need to feel that the process was fair and that they had a role in it. So by providing a summary of what they just said, you not only know that you have accurate information, but you also know that the party knows that you have accurate information. And this is important. Pauline's summary was accurate and complete, yet succinct. Now, in the next vignette, let's watch Pauline use a summary for a different purpose. In this vignette, she's going to summarize to help make the statement by the attorney more accessible and understandable for the self-represented litigant, translating more technical terms that might have been used to intimidate the self-represented litigant to more understandable terms. Let's watch.
Like we've discussed, the 3-day notice is expired. There's no affirmative defenses that Marissa has.
she has legally no foot to stand on. If we go to court, we're going to ask for attorney's fees under paragraph 28 of the lease provision. We're going to ask for court costs, filing fees, back due rent, all the holdover that she's still there. And this, when it goes to court, we're going to cancellation of the lease. She's going to forfeit the property. She has no ground to stand on.
So Neil, let me make sure that I've understood you correctly. You and Carla have given Marissa some time leading up to today to do a couple of things, to pay the rent that was owed to Carla, and to also remove the dogs or get rid of the dogs from the property. And the time for that has come and gone, and neither of those things have happened. So today, if you were to go to court, you would argue that you have some language in the lease that would allow for you to get some attorney's fees if you win in court today, and that there were other costs that you might be able to get as a result of a judgment if one was given to you, including the amounts of money that you paid to file this paperwork, the amounts of money that you had to pay out for a process server, things like that. Correct?
Correct.
So, and then you also mentioned that you would also ask the judge to make Marissa leave the property if you were to win today.
Yes,
correct?
we would.
Okay.
So here, Pauline translated what the attorney was arguing into more accessible language for the self-represented litigant. So the attorney used terms like 3-day notice, affirmative defense, paragraph 28 of the lease. And so in each of those cases, Pauline made a mental note that when she was going back to summarize, that she would translate those things. And 3-day notice went to time, affirmative defense said some reasons for her actions. She talked about the idea of attorney's fees being available if they won. And so it's just listening for terms. Sometimes they're technical, sometimes they're terms, for example, like forfeit, which may be too technical or fancy for some self-represented litigants if they're not educated. And so you have to use your judgment to think about what are the words that are likely not to be understood or potentially not understood. And then when you do the summary, put them in terms that are accessible. Encouraging persistence and patience. Parties being persistent and patient are often the keys to a successful mediation, but self-represented litigants who have limited experience with legal negotiations often fail to appreciate that obstacles and difficulties are simply common features of disputes. And so your job as the mediator is to normalize this process, to normalize that there will be obstacles, that there will be times when there is little movement in the mediation. Parties who are persistent and patient in mediation gain power. We know this because of negotiation science tells us that people who stick with it and are patient are simply more powerful in the negotiation. And so helping parties to understand the importance of the stick-with-itness that good negotiators have helps to balance power in negotiation for self-represented litigants. Now, the problem here is that you can come up against some ethical issues. So, if you push too hard, if someone wants to give up, and you push too hard to keep them in the negotiation or the mediation, then you may be coercing them in the mediation process. And we know that you cannot coerce them even to stay in the process. And so what I like to do is to let them know the consequences. To say, if you give up now, then you're going to have to go to the court, and they're going to make the decision for you. My experience, I tell them, is that I think that there is still a time to make some progress here, even though it looks bleak at the moment. Again, normalizing the obstacles and difficulties goes a long way in helping parties to stick with it. You say, these kinds of frustrations and inflexibility are just part of the mediation process, and my experience is that this is still a case that could resolve itself if we spent more time on it. And then give them the choice. And if they still want to quit, then they quit. But at this time, you're doing your job and helping them to see the mediation process for what it is and not something they think it ought to be. We've already discussed calling breaks as a mediator's tool in the context of the mediator's opening statement. But it's such an important tool to balance power, it's important to spend just a minute on it here in this section. Calling breaks is something that you as the mediator can do, and again, empower the parties to call breaks when they need them as well. And the idea of breaks is simply to take a rest from the process. This is particularly important for self-represented litigants who often need time to process or may need to make calls to people who support them or ask questions of people who have information, whether it's technical or factual information, to help them. Calling breaks can help the self-represented litigant make better settlement decisions. There are 3 common reasons for a mediator to call a break. Emotions are destructive. So this is where the parties are interacting in ways that doesn't seem to be moving the process forward. One party is intimidating another, again, a particularly important one, with self-represented litigants facing parties that may have more power or be more aggressive or sophisticated. And then a participant needs time to process the information, again, a very important one for self-represented litigants. A break is when the action stops. It's when you don't meet with any other party even separately. But now, somewhat relatedly, let's go to when you break the joint session to meet separately with each party, another important tactic in the toolbox for helping self-represented litigants. Conducting separate meetings. Conducting separate meetings, or the caucus, is an extraordinarily important tool when self-represented litigants are involved. It is a way to separate the parties and so that the mediator has enormous control over the kinds of interactions that the participants have, and in this way can really mitigate the kind of intimidation or aggressiveness that one party might use to overpower the other party, and therefore you're balancing power. Now, there are great reasons to have joint sessions even when self-represented litigants are participants, so we need to use the separate meeting judiciously. Conducting separate meetings is so important to balancing power when self-represented litigants are involved. We're going to go through it in some detail, covering even some of the basic material that you would have seen in your original mediation course. But if you do this well and you use the foundations of a good separate meeting, you're going to go a long way in helping the self-represented litigant participate as fully as possible and balance power in an ethical way. The trend in civil litigation is for mediators to conduct the entire mediation using separate meetings. In other words, going back and forth in a sort of shuttle diplomacy among the parties. However, a separate meeting is a tool that should be judiciously employed, not a default mediation style. There's lots of value that can be gained by having the parties in the same room at the same time. It is helpful for the attorneys and parties and the mediator to communicate about how separate meetings will be used during the mediation, at the beginning of the mediation process, during the mediator's opening statement. Now let's look at the details of a recent study that supports the judicious use of separate meetings as opposed to using it as a default mediation style. In January 2016, the Maryland Judiciary published a study that's relevant to separate meetings and caucuses, among other things that we'll mention later in this training. The study's findings regarding caucuses or separate meetings supports this idea that separate meetings ought not be a default style, that you should always have a reason to call a separate meeting. The short-term findings of the study found this, that the greater the percentage of time participants spent in caucuses, the more likely participants would feel one of the following: that the ADR practitioner controlled the outcome or pressured them into a solution, and that the increase in a sense of powerlessness or an increase in the belief that conflict is negative. Now, also a short-term finding, the greater the percentage of time in caucuses, the less likely the participants report that they were satisfied with the process and the outcome, and the issues resolved with a fair and implementable outcome. Among the long-term findings of this study for the greater amount of time spent in caucuses, that the more time spent in caucuses, the more likely it was that the case would return to the court later within the year. A mediator should call a separate meeting with a specific purpose in mind. There are several important reasons to call a meeting. One is to obtain additional information. Parties are often reluctant to share their true interest or important facts if the other party is present, and so therefore giving
each party an opportunity to share additional facts that they may not have felt comfortable sharing in the joint session is often helpful. Another reason is to provide an appropriate climate for reality testing, helping parties to evaluate or formulate offers and discussing negotiation strategy. These are things that are risky to do or cannot be done when the parties are all present in the same room. For example, if you're asking a question about how a party is going to prove certain facts or support certain damage requests, if done with the other party in the room, it can be seen as an attack or that you're being biased in the mediation. The same question, if done in a separate meeting, there is less risk that it will be perceived as biased, but rather that you're helping the party to look more deeply at their dispute. Another reason is to provide relief from destructive emotions. Emotions are part of the mediation process and can be very helpful. But if parties become too aggressive or too emotional, they often confuse good decision-making, and therefore separate meetings can help the parties look more realistically at their options.
Let's take a look at a dispute between a bride and a wedding photographer where I act as mediator, where I think that the emotion in the room has gotten destructive enough where I want to call a separate meeting.
So Natasha, let's start with you, and I want to hear, since you filed the complaint, I want to hear, what are the most important concerns that we need to keep in mind as we're starting to move through this problem?
Okay, well, let me just start by saying that this was supposed to be the best day of my life, and I mean, at the time, it was. I had a great time, and then I get the pictures back, and that's really where my nightmare begins, and you're really looking at the person here who caused that. I mean, I got everybody, I spent all this money, and you can't even take a picture of everybody who's there. Like, isn't that basic photography 101? If you even went to school for what it is that you do. I mean, I know that these events for you are just another paycheck, and that's really all you care about, but my family wasn't even in the picture.
Maybe we can just direct it at me. That would make, I think, the most sense in terms of what the concerns are. Thank you.
Okay, so, I mean, I paid for these dresses, these makeup artists, this wedding, 100 people to be there. And half of them made it into the pictures, and that doesn't include my parents, that doesn't include the whole bridal party. I mean, I don't even know who this guy is. He just, now I understand why you charge what you do, because the work is just useless. I wouldn't pay that much money for something
now you're telling me what you want.
It's pretty much just tissue paper at this point, because it's worth nothing. I mean, my aunt sat there and meticulously put together this cake that, I mean, we've been talking about this my whole life, and she spent all this time.
It's nothing special.
Okay, I mean, really, this is something that my aunt worked hard for and would charge hundreds and hundreds of dollars.
Just let me just remind you, we had talked about when I gave a little description of the process of that it's only going to work if we don't put blame or personal attacks or interrupt, and I know that's hard to do because you both feel strongly about this issue. So maybe what we can do is, if it's okay with you, maybe we can just meet separately first, just to get a sense of where we're at. So is it okay if I just meet separately with you, Natasha?
I'd love to talk to you about this.
And then, Bob, what I'll do is we'll come back and I'll meet with you after that. Is that okay?
You'll see what I'm dealing with.
Oh, okay. I think it's going to be better that way. Okay,
Sure.
so let's just take our break, and I'm going to meet with Natasha first, and I'll just ask you to step outside, and I'll kind of get you about 15 minutes.
Okay.
Okay, great.
The line between healthy emotional catharsis and destructive emotions is a hard one to draw, and many mediators draw it at different places. For me, in this mediation, when the bride began personal attacks that had reactions from the photographer, it seemed to me that these emotions were getting out of hand and not going to help the mediation process. And so what I first tried to do was have the bride direct the opening to me. And when this didn't seem to work, the only place for me to go was to have a separate meeting. Some people might have had this go on longer, but in my experience, once the blame happens and it gets reactions from the other side, the mediation typically doesn't move in a good direction unless you either call a break or you have a separate meeting.
Tips for separate meetings. Always give the parties an estimate of how long the separate meeting will be. For example, if I meet with the plaintiff, I'll say to the defendant, I think I'll be about 15 minutes with the plaintiff. If I'm longer, I'll come check. And the reason is so that the other party will not begin to negotiate with themselves and begin to wonder what is going on in the other room. Give the waiting party some homework to think about. This might not be something you can do in the first separate meeting, but later on, once you understand what the obstacles are in the negotiation, you might give the waiting party something to think about. For example, you might say to the plaintiff, while I'm with the defendant, you might want to think how you're going to prove the medical costs. Be conscious of duration imbalances. Meeting longer with one party or another is inevitable in the mediation process. However, if the imbalances are really profound, you're meeting with 10 minutes with one side and 45 minutes with the other, you need to help to manage that by explaining to the parties as to why you're needing to meet longer with one party or another. To not do so leaves the parties thinking if you're biased or not, even though you may be working very hard for both of them.
Keep the meeting as short as possible. This helps to keep the mediation moving and also kind of mitigates the ability for the other side whom you're not meeting with to negotiate with themselves. If you meet with one party in a separate meeting, you always have to meet with the other party in a separate meeting. It keeps things balanced. Even though you may be meeting with one party to help the whole mediation process, the party with whom you don't meet may think that you favor the party that you're meeting with. So you always have to be mindful of how meeting with parties are perceived by the parties themselves.
Confidentiality. You should remind parties at the beginning of a separate meeting that if they want anything discussed to be kept private or confidential, that they should let you know. This is in contrast to what some mediators do, which is to say, everything we talk about will be kept private or confidential. The reason why you want to ask them to let you know what is confidential is so that you set the meeting up so that everything they tell you is not confidential unless they accept it from the discussion. This allows you more information than you might otherwise get. If appropriate, at the end of the meeting, check as to what aspects of the discussion are confidential. In other words, say, is there anything we discussed that you want me to keep private? The separate meeting structure. This is a typical structure of the first separate meeting that you might have with a party. First, emphasize confidentiality. This helps the party to feel comfortable, to know that if they do say something they ultimately want to keep confidential, that you'll keep it confidential. It allows them to open up more. Next, ask if they wish to add anything that they didn't say in the joint session. This is very important. Parties often forget things, or as we spoke about before, feel uncomfortable telling the other party facts or interests in the joint session. Third, review issues and interests. Whatever issues or concerns you heard in the opening statement, this is a good time to summarize them again to make sure you understand them and for the party to add to what they've said. If appropriate, explore potential solutions. And next, generally, try to keep the first separate meeting relatively short.
Let's return to the idea that we talked about just a moment ago about when you should call a separate meeting and apply that principle to the vignette we just saw. As you saw in the last vignette, when the parties became unproductive in their conversation, in this case because of blame, I called a separate meeting. Another reason is aggressiveness. The parties just become too aggressive and therefore they're not being productive. Two other common reasons to call separate meetings are sharing information with the litigant that you don't feel comfortable sharing in front of the other party. So this could be an explanation of the litigation process that if you did in front of the other party may feel like you're helping the party you're explaining this to too much. Or getting information, hearing something in the narrative of the mediation from one party that raises a question that you don't feel comfortable asking in the joint session. Let's take a look at me conducting a caucus or separate meeting with a plaintiff in a landlord-tenant dispute. The reason why using this structure with self-represented litigants is so important is that it gives them a way to think about the dispute. It gives them a way to prepare for a further discussion in a problem-solving way. Let's watch what I do, and then we'll discuss it.
So, Anna, thanks for meeting privately. So what I'd like to do is just remind you about confidentiality. So anything that we talk about here, At the end, I'll just check in, and if there's something you don't want me to share with Matt, I won't, right? So hopefully this will help you just get a sense that, you can feel comfortable talking about it. And again, I'll just remind you, the more I know about this and the more I know about you, the more likely it is that we can come up with something that works. So is there anything, I always like to start, is there anything that you want to add that you didn't mention for whatever reason in the beginning session?
Yeah, Matt mentioned that we had this little kerfuffle or whatever it was about repainting and the stove and all that kind of stuff, and he said that I, threatened to sick my parrot on him, which is absolutely ridiculous. I could never sick her on anyone. She's just like a loving little feather ball instead of a fluff ball.
Mm-hmm.
So that was kind of a little odd to me, and I just didn't really want to attack him, partly because I did say that I was going to paint the building in an interesting way, but it really wasn't, it's kind of an empty threat. I really wasn't gonna do anything. I just really want my stove fixed, and I just need him to fix it. So I didn't mention it because I didn't want to go there.
Okay.
And I don't really want him to know I didn't mean it, because I really, really want my stove fixed.
Okay, so this was sort of an empty threat, but you don't want me to tell him about that?
Yeah, not right now, but definitely, my parrot isn't going to hurt anyone.
Okay.
So that's really the one thing that I didn't mention initially, because it not so great for me.
All right, so the purpose that I like to meet just separately is one, to find something just like that. Doesn't mean you didn't really want to share, again, understandably. But I also want to see if I can really get a better sense of what are the most important concerns that we need to make sure that if you can meet, then maybe we can get some agreement. So one of the things I you've mentioned a couple times, understandably, is the stove. So that's very important to you you get the stove done as quickly as possible so you can start cooking your meals, not have to eat out.
Yes.
Do you want to stay in the apartment?
Absolutely.
Okay.
I do not want to leave at this particular point in time. I want to be able to stay and enjoy myself as an artist and be able to create and enjoy it. I have a grant, and that's up in 2 years, and that's when I plan on leaving this area.
Okay.
So I'd really like to stay, because I put a lot of work into that apartment, and it's beautiful right now.
Okay, and so that kind of leads to another, that you'd like to keep the apartment painted the way you've painted it, because it seems to give you a lot of pleasure.
Yeah, as an artist.
Okay. So what I'm hearing so far is that, the stove is really important to have. Staying in the apartment is something that you'd like, because it seems like the apartment's working out for you and the area's working out for you.
Yes.
All right. And then and having the inside of the apartment remain how you painted it, because it gives you a lot of joy, that would be important to you as well.
Yes.
Okay. But again, you'd like to have these, but the front door and having paying $200, these are things, I guess, are less of a concern for you.
Yes.
Okay.
I agreed completely. I see why those two things are a little bit concerning to him. So, but, I mean, if I add some liveliness and some value, I should be recognized for it.
Okay.
So, I think that's kind of what's more important, is the recognition by him that I'm not destroying his property.
Okay. Are there any other major concerns that I've left out that you want to share with me now?
I don't think so.
Okay.
But really hit the parrot. I don't really know where he's getting this complaint thing about my parrot.
Okay.
She really does stay in her cage unless I walk her on the leash.
All right. Again, this is just to check in, and I want to do the same with Matt.
Okay.
So I think I have a good sense of what's important to you. And again, the only thing that you've said so far that you don't want me to share is maybe that that you're not really very serious about, painting up his apartment. So, but let me just throw this out. I'm not sure it'll come up, but I will say that it might be helpful, and it's totally up to you. I will say that it might be helpful if you either share during the session or allow me to share with him that you really weren't serious about sicking the parrot, that it's a very good bird, and that you really weren't serious about doing anything at the outside apartment. It just seems to me, just from what we just saw, that Matt seems to care a lot about the building. It was his dad's. He seems to take some pride in it, and so that that threat, as empty as it may seem, if we know that was a little bit just blowing off steam, it may soften him a little bit. What do you say about that?
I can think about it.
Okay.
I see where you're coming from. I'm nervous that he won't fix my stove, and he's going to keep saying that, I'm destroying everything and blaming everything on me if I don't have any real power. That's kind of what I feel like I'm lacking a little bit right now.
Okay, but you're sort of open to the idea of at some point, if I say, this might be a good time to do that, to we can revisit the issue?
Yes.
Okay. Is there anything else that you don't want me to share that we've talked about?
No. I think
if it's relevant, it comes up, I can share it with Matt.
Yeah.
Okay.
I think so.
Okay, good. All right, good. So I think I have a good sense, or a better sense, of what is the most important, are the most important things to keep in mind. And so what I'm going to do now is I'm going to meet with Matt. I'll be with him about as long as I've been with you, is about 10 minutes or so. And again, you might want to think now, I'll come back, as if you want to stay in the apartment, I think part of this is to maybe think about some solutions, right, that can help. And maybe before we sort of jump back into Matt, what do you think are his major concerns? I mean, what do you think that, so you said, you've already said that, maybe not paying for the paint is something you can understand, having the outside of the apartment done. Just from what you heard, what else do you think he really cares about that we need to keep in mind?
I'm sure that I guess being able to re-rent if and when I do leave, being able to re-rent that, he said that at some point,
he did.
So I think that's probably something that he might bring up, and obviously getting paid for what he's due now.
Yeah, for the rent.
Obviously, as a landlord, that's going to be one of his concerns, is being paid. But I'm hoping that the happiness of his tenants in general and the enjoyability of the property is also something that he's concerned about. And not just certain tenants, but all tenants, including myself. So I'm hoping that's one of them, is that he cares that we're happy and that we can enjoy our houses as we would like to.
Okay, good. So again, I'm going to meet with him, but as you start to think about some solutions, and we'll come back, think about what kind of solution you think might work for you, but also really take in consideration some of the things that you just talked about for Matt.
Okay.
Because in the end of the day, one of the things about mediation is that both parties have to agree to a solution, and if we can't, then we're back in court, and that may be where we go, but. At the end of the day, then you lose control of who decides the case. In that case, the judge is going to decide. And here, if you can craft something that seems to work and satisfy some of your goals, but also take in consideration Matt's, then it's in your control.
Okay.
Okay? All right. So I'll see you in about 10 minutes.
Thank you.
You're welcome.
Following this structure for the initial separate meeting allows me to move the process forward in a few different ways. One, I get additional information. I always ask that question, is there anything else you wish to add that you didn't feel comfortable adding at the joint session? And invariably someone says something that they didn't say before. And I get that information, which is helpful. Here, the plaintiff said that she had made these threats about painting up the place, and they were really idle threats. I also have the ability to get the most important concerns, and I ask it in this way intentionally. What are your most important concerns? And it helps me to focus the mediation in ways that I might not be able to. I also do some perspective shifting. I try to get them to think about the other side's interests in the case. That's just as important as them thinking about their own interests. I also try to do some coaching. And so here I said it might be helpful at some point in the mediation for you to say that those threats that you made about painting the building are idle threats. She wasn't ready to do that yet, but it plants the seed that this might be something, if she did, will gain some flexibility on the other side. And then finally, I ask her to do homework. This idea that when I meet with the other side, that she is still working, that she's going to be thinking about ways to solve the problem. All of this helps to move the process forward in very significant ways if you follow the structure, especially with self-represented litigants.
You will now be directed to a short quiz to assess your understanding of the information just presented.